And with attention coming from around the world after the killings of a married couple along a hiking trail, critics are questioning why the accused killer's recent court date went behind closed doors.
Andrew McGann pleaded not guilty, but the media and public couldn't see that after the judge closed the courtroom. Bo Russell looks into how often that's ever allowed.
I've gotten a lot of questions through email and social media about McGann's arraignment, but before I get to those, let me back up and quickly recap what's happened since McGann was arrested. On August 1st, Andrew McGann made his first appearance before a judge for an 8.1 hearing. Media was allowed into the lobby of the Washington County Jail's courtroom, where the courtroom's live feed was played through a TV in the lobby. A few weeks later, on August 14th, media arrived at the county jail for McGann's arraignment and were greeted by a court order on the door, prohibiting media from recording inside or around the courtroom. That's not unusual in high-profile cases like this one. What was unusual, however, was that the TV and speakers were turned off, and black paper covered the window looking into the courtroom. When asked about the decision to close the hearing to the public, Washington County Prosecutor Brandon Carter had this to say.
This office has released all of the facts of the investigation that it's ever going to release in this case.
Following the hearing, I posted this video on 5 News social media accounts explaining what had happened at the county jail. We immediately received comments and emails seen here, raising questions and concerns as to why the hearing was closed to the public. Even State Senator Terry Rice of Waldron raised questions about this during a Game and Fish in Arkansas State Police meeting.
I read an article while we were sitting here about the judge closed the courtroom today and even taped over the one window that you could see in the courtroom, but I don't understand that either.
I spoke with Rice again today. He tells me that there needs to be transparency and that laws are in place for a reason. According to Arkansas State Code 1610-105, a judge can only close a hearing to the public if they file an articulate and specific reason as to why the public's viewing of the hearing would hinder a defendant's right to a fair trial. So that catches us up to speed on the August 14th arraignment. Since then, 5 News has submitted Freedom of Information Act requests to the Washington County Prosecutor's Office, Public Defender's Office, and the Sheriff's Office, asking for all recorded discussions regarding the decision to close the arraignment to the media. Now, just moments ago, we received a response from the prosecutor's office saying the 4th Judicial District Prosecuting Attorney's Office does not have any records relevant to your request. The decisions referenced in your inquiry were made by the court independently and without any motion or input from this office. I reached out to Judge Joanna Taylor's office multiple times and received the same response each time. We're not going to talk about this case. Earlier today, I spoke with a member of the Judicial Discipline and Disability Committee. They were not able to provide comment on this case, but did tell me there is, quote, rule of judicial conduct that judges are expected to follow.
Bo Russell reporting for us today. We're also expecting a gag order to come out in this case soon. Again, state laws do say a reason has to be given to close a trial or issue a gag order.
That reason, if there is one, has not been made public. We have filed those open records requests and will hopefully have more information soon.